Illegal immigration. If there is one issue that has found strong support among the Assamese, it is this issue. And no, I'm not just talking about recent times. This issue was highlighted before the British left India, just after the British left India, and well, since the 70s, it has been probably the strongest rallying cry across most party lines in the state. But what happens next? I'm Kalyan Deb, and in this episode of Decoded, we ask the hard question: what happens next? For months.
The village of Assam in the 75th Independence Day.
On Thursday, October 17, the Supreme Court, in a majority ruling, upheld the constitutional validity of Section 6A of the Citizenship Act, which grants citizenship to immigrants who entered Assam between January 1, 1966 and March 25, 1971. The Constitution Bench was headed by Chief Justice of India D.Y. Chandrachud. Justice Surya Kant authored the lead majority verdict on behalf of himself, Justice M.M. Sundaresh and Justice Manoj Mishra, while Chief Justice Chandrachud delivered a concurring opinion. Justice B. Pariwal rendered a dissenting opinion and declared the statutory provision unconstitutional but with prospective effect. Now, many of you must have these questions. What does Section 6A of the Citizenship Act stipulate, and how did it come into existence? Section 6A is a special provision inserted into the Citizenship Act in furtherance of a memorandum of settlement called the Assam Accord, signed on August 15, 1985 by the Rajiv Gandhi government at the centre at that time and the All Assam Students Union. This agreement followed the 6-year-long bloody agitation against the entry of migrants from Bangladesh into Assam. I do not need to inform our viewers about how Assam has long faced challenges with the illegal entry of immigrants from then East Pakistan and now Bangladesh due to porous terrain of its border, which is characterized by numerous streams and rivers. A key feature of the Assam Accord was to identify the foreigners residing within the state. Clause 5 of the Assam Accord set January 1, 1966 as the base cutoff date for detecting and removing these foreigners. However, it also allowed for the granting of citizenship to immigrants who arrived in Assam after this date, but only up to March 24, 1971. More importantly, Section 6A was incorporated into the Citizenship Act to fulfill this particular objective. All persons of Indian origin who entered the state before January 1, 1966 and have been ordinarily resident in Assam ever since shall be deemed citizens of India. It also provides that individuals who entered and resided in Assam after January 1, 1966 but before March 24, 1971 and have been detected to be foreigners by entities such as Foreigners Tribunal would have the opportunity to formally register themselves in compliance with the rules framed by the Union government. Following such registration, they would be entitled to all rights as enjoyed by any other citizen in the country, except the right to vote for a limited period of 10 years. So, who challenged the Clause 6A? The Assam Sanmilita Mahasangha, which is an umbrella organization of several indigenous ethnic organizations, contested Section 6A in 2012, alleging it was discriminatory, arbitrary and unlawful. The Mahasangha argued that the provision of distinct cutoff dates for regularizing illegal migrants in Assam versus the rest of India was unfair. The organization requested the court to intervene by instructing the relevant authority to update the National Register of Citizens or NRC for Assam based on information from the 1951 NRC rather than relying on electoral rolls before March 24, 1971. Subsequently, other organizations formed from Assam also filed petition challenging Section 6A. In contrast, the centre argued that Article 11 of the Constitution confers power upon Parliament to enact laws for the acquisition and termination of citizenship. Solicitor General Tushar Mehta, appearing for the centre, notably blamed the West Bengal government's policies for delaying the completion of fencing along the Indo-Bangladesh border, which could have prevented infiltration and illegal immigrations. Other respondents, including the NGO Citizen for Justice and Peace, defended the provision, arguing that striking it down would render hundreds of residents stateless after over 50 years of residing in Assam. Upholding the constitutional validity of Section 6A, Chief Justice D.Y. Chandrachud said the statutory provision balances the humanitarian needs of migrants of Indian origin and the economic and cultural impact of such migrants on Indian states. Now that I have talked so much about legal stuff, let us try to break down the significance of the verdict. The Supreme Court ruling is expected to have a significant bearing on, you guessed it, the National Register of Citizens or NRC. The dates set in Section 6A form the basis for the final NRC prepared in 2019. Although the NRC process has been in limbo for the past 5 years, October 17th's ruling upholds the basis on which it was prepared. Here's something I did not think I would be saying. No sooner did the verdict come out, it was welcomed by all sides of the political spectrum. Assam Congress President Bhupen Kumar Bora welcomed the Supreme Court's verdict, calling it a significant ruling in favor of the Assam Accord. Interestingly, although expectedly, the All Assam Students Union advisor Samujjal Bhattacharya also hailed the Supreme Court's decision. He stated that the need of the hour is to implement all the clauses of the Assam Accord. Other parties such as Aam Aadmi Party Assam, regional parties such as Assam Jatiya Parishad and Rajya Dal also welcomed the verdict of the Supreme Court. And the BJP too was not far behind. BJP has termed the Supreme Court's verdict on the constitutional validity of Section 6A of the Citizenship Act as historic. Speaking to media, BJP MP and spokesperson Ravi Shankar Prasad said that the law was challenged by various groups, but the constitutional bench of the Supreme Court today has given recognition to this. Remember this man? Of course you do. I can safely say that even though the CAA was approved during his tenure, he remains probably one of the most loved Chief Ministers of India. But before October 17th's ruling, Sarbanand Sonowal probably played the biggest role in working towards a solution to the illegal migrant issue. Sonowal played a crucial role in the removal of the Illegal Migrants Determination by Tribunal Act or the IMDT Act, a contentious law that governed the detection and deportation of illegal migrants in Assam. The IMDT Act placed the burden of proof on the complainant to prove that a person was an illegal immigrant, which was seen as a significant departure from the Foreigners Act of 1946, where the accused had to prove their citizenship. Sonowal, then a leader of the All Assam Students Union, which spearheaded the Assam movement against illegal immigration, challenged the IMDT Act in the Supreme Court. He argued that the act was discriminatory as it only applied to Assam, making the detection of illegal immigrants difficult in the state compared to the rest of the India. This resulted in the influx of illegal migrants from Bangladesh, which according to Sonowal posed a threat to the indigenous population, its culture and its resources. In 2005, the Supreme Court ruled in favor of Sarbanand Sonowal and struck down the IMDT Act, declaring it unconstitutional. The court observed that the act had created the biggest hurdle and has been the main impediment or barrier in identification and deportation of illegal migrants. The judgment was hailed as a significant victory for those opposing illegal immigration in Assam. Now coming back to the NRC. You see, there is a reason we have not heard anything on the NRC ever since the final list emerged nearly 5 years ago. While October 17th's ruling surely clears any doubt, the challenges are clearly far bigger and much more serious ahead. Here is a simple question. If I'm not an Indian, does it automatically mean that I am a resident of some other nation? No. You see, the NRC was not mandated by the Supreme Court. The Supreme Court had instead asked for updating the 1951 NRC list. If you can prove linkage to people on that list, you were simply put safe. The larger question remains, what if you cannot? You see, the NRC does not address the question because, as I said, that was not its mandate. What happens to those who cannot prove that they came to India before 1971? We do not know, and that is where the problem becomes far bigger than what we think. A simple question: if, say, Nepal tomorrow says 4 million people in their country are not Nepalese citizens, will those 4 million people actually become Indian citizens? Of course not. Does India have any reason to take them back? Of course not. Does Nepal have the power to kick them out of the country and make them stateless? Of course not. The situation in India is no different, and we have been repeating this time and again. India has absolutely failed at bringing up this issue of ensuring that illegal immigrants return to, say, Bangladesh, where they came from. And why on earth will Bangladesh accept them? The BJP, which has always advocated itself as the voice of the indigenous people, sat in power for 10 years in the center and 8 years in the state, but never raised the issue diplomatically with the Bangladesh government. And now Bangladesh does not have a government. Their ousted leader is in India, and the future of India-Bangladesh relations hangs in the balance. So while we all welcome the SC ruling, it is clear that the issue of illegal immigration is not even close to being solved, and that it would take a lot more than judgments and orders to ensure that Assam's burning issue becomes a thing of the past. The thing is, as we have learned, keeping the issue burning is far more profitable for the political parties than solving it.
Don't forget to like, share, and subscribe to EastMojo. For any queries, put them down in the comments section below and press on the bell icon for notifications.